Well, good afternoon, and in what appears to be a rather fast-moving environment, can I welcome you to this hearing on the detention of Julian Assange and its chilling effects on human rights. And I should mention that this hearing is open to the public and is being recorded for subsequent transmission on the Assembly's YouTube channel. And I alluded to the fact that there are developments in various places, but more particularly with regard to the situation of Julian Assange. We have now received reports, as of this morning, that there has been a proposed plea deal or arrangement with the US prosecuting authorities, in terms of which Julian Assange will tender a plea of guilty to one charge under the US Espionage Act, and the US prosecuting authorities will move that he be sentenced by a US judge to a period in imprisonment of 62 months for that espionage offence. In circumstances where he's already served more than 62 months in prison in the United Kingdom, while awaiting and challenging extradition to the United States, he will, it is proposed, be released if the United States judge accepts the plea deal from the United States prosecutors. We will know the answer to that question after the hearing in the US Commonwealth of Northern Mariana Islands, which should take place at about midnight our time. The reported catalyst for the US prosecutors to make the plea deal was the decision of the Court of Appeal in England and Wales to grant Julian Assange leave to appeal his extradition on two grounds. And the principal ground was that the intended extradition would impinge upon and be in conflict with his right to freedom of expression under Article 10 of the Convention. So that brings us full circle, as it were, back to where we are this afternoon. And I would like, in that context, to welcome the experts who've been invited to address us on these matters. First of all, Professor Fionnuala Ni Aolain, and I do hope I've pronounced her surname correctly, but I'll be corrected if not, who will join us online. Thank you, Fionnuala. Ms. Rebecca Vincent, Director of Campaigns for Reporters Without Borders, who will also join us online, and Mr. Simon Crowther, Legal Advisor to Amnesty International in London, who is with us this afternoon. So can I then give the floor to our rapporteur, Sunna Aevarsdottir, for a brief introduction. Thank you, Sunna.
Thank you, Chair. Thank you, Chair. Dear Mr. Chair, dear colleagues, ladies and gentlemen, today's hearing could not come at a more relevant time. I'm thrilled to be able to say that Julian Assange was yesterday released from Belfast prison and is en route to the US Marina Islands, as our chair just told us about, where it is hoped that he will finalize a plea deal that will finally result in him regaining his freedom. While I very warmly welcome this positive development, my work doesn't end. We still need to look back on 14 years of his confinement, and we have to draw the right conclusions so that no other journalist, whistleblower, or human rights defender has to go through the same ordeal if he or she or they report on matters of utmost importance in a democratic society. I'd like to thank everyone for their interest in discussing this important case. Now, it is my pleasure to welcome here in Strasbourg Mr. Simon Crowther from Amnesty International. Thank you, Simon, for having come from London for this hearing. Online, I have the pleasure to welcome Professor Fionnuala Ni Aoláin. She is the holder of the Robina Chair in Law, Public Policy and Society, and Faculty Director of the Human Rights Center at the University of Minnesota Law School, and concurrently a Professor of Law at the Queen's University of Belfast School of Law. Professor Ni Aolain is former UN Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism, a very important issue in this respect. Also online joining us is Ms. Rebecca Vincent from Reporters Without Borders, and I thank you also sincerely for being with us. Now, before we begin, let me express my condolences to Ms. Vincent for the untimely passing of Mr. Christophe Deloire, the Director General of Reporters Without Borders. He was a dedicated and passionate defender of independent journalism and media freedom. Our sympathies are with his family and colleagues at this difficult time. Turning now to today's hearing. I've asked Professor Ni Aolain to talk about her perspective on how to balance the respect for human rights and preserving national security and counter-terrorism policies. From our previous discussions on this topic, I met with her in London. I know that a lot of our colleagues are particularly interested in this matter, and I hope that Professor Ni Aolain's intervention will help us clarify some of these issues. Over the past several years, Mr. Crowther and Ms. Vincent have been closely following the extradition proceedings of Julian Assange, and their respective organizations have tremendous experience in monitoring the state of freedom of expression and media freedom. Ms. Vincent will talk about the impact that Mr. Assange's prosecution and detention have had on journalism and freedom of expression. Mr. Crowther will share his views on this case and also focus on its possible impact on whistleblowers. And I look forward to hearing from our experts and to the discussion we will have with them. Now, I suggest to the chair that we will invite Professor Ni Aolain to speak first, followed by Ms. Vincent, and last but not least, Mr. Crowther. Thank you.
Thank you, Sunna, and I'm very pleased to invite Professor Aoláin to address us. And can I say that each of the experts should feel free to address us for up to 15 minutes. Thereafter, we will open the floor for questions from members and seek to group those into convenient packages, as it were, and then invite the experts to respond to those questions. So, Professor, if I could invite you to please address us.
Excellencies, ladies and gentlemen, I'm really pleased to join you today for the committee's deliberations, and my remarks will address how to balance respect for human rights and specifically freedom of expression while preserving security. I was particularly pleased to meet the rapporteur while she was in London right after her visit to Belmarsh prison, and to discuss many of these issues firsthand. I held the role of UN Special Rapporteur for Counter-Terrorism and Human Rights from 2017 to 2023. And in that time, I observed systematic and structural abuses of human rights and the rule of law, hardwired into global, regional, and national institutions, as well as in normative legal structures. From 2001 onwards, global national security has metastasized and remains a cogent threat to the integrity of democracy and the protection of human dignity across the globe. The expansive growth of national security architectures, not just in authoritarian regimes from China, need we mention Xinjiang, to the Kingdom of Saudi Arabia, to Egypt, as well as to backsliding and security-infused democracies such as the United States, has not made us safer or more secure. My remarks today draw on my experience at the very front line of the global fight to protect human rights while countering terrorism and advance security, not just because human rights protection is the morally just position, consistent with the core tenets of democracy and the Council of Europe, but also, frankly, because to successfully and efficiently prevent extreme violence and insecurity in our societies, we must protect rights. Security and human rights go hand in hand, and security without rights is like a colossus with clay feet, and a failure to connect security and human rights. As we see in places such as the Sahel, but also in the prosecution and persecution of Julian Assange, represents the fundamental fallacy that society is not safe when we excoriate rights from security. My remarks also space in civil society, which has been made available to the committee. So as we celebrate this 75th anniversary year of the Universal Declaration on Human Rights, the global state of human rights remains fragile and deeply contested, and all of us know it. For decades, civil society organizations and the UN human rights mechanisms have been warning about the persistence and challenge of counterterrorism in their practices. But the truth is that this information remains at the margins of counterterrorism and security conversations, and we are overdue a reckoning on global, regional, and national consequences about the nature, form, and realities of human rights abuses perpetrated in the name of fighting terrorism, as well as the sustained cover that the discourse of national security has provided for egregious and sustained human rights violations. So let me say a couple of things about what we see happening at this interface point. First, civil society, including human rights advocates, lawyers, whistleblowers, and citizen journalists and journalists more generally, experience complex...
Professor, I'm sorry to interrupt. We're having difficulties with the signal, and in order to reduce the bandwidth, and so we can hear you clearly, would it be possible for you to switch off the video and speak to us in that way? And hopefully that would improve the situation. I do apologize for interrupting you.
No, thank you for interrupting me, Chair. Better to interrupt me than to miss the sound. So let me make a couple of general comments about the patterns we see. Civil society, including human rights advocates, lawyers, whistleblowers, and journalists, experience complex and compounding misuse of counterterrorism and national security practices in connection with and connected to the ever-growing security architectures across the globe. Another special rapporteur, Irene Khan, has noted in her communications to the US government about Mr. Assange and urging them to drop charges against him is that the actions against him, quote, set a dangerous precedent that could have a chilling effect on investigative journalism in the US and elsewhere in the world. Civil society actors, including citizen journalists, whistleblowers, humanitarians, and lawyers, don't experience singular or indirect counterterrorism and security measures in isolation. What they experience is what we might call the playbook of misuse. And here I note the extent to which Julian Assange is an emblematic case where his criminal charging, extended detention, and proposed extradition, and even this plea bargain underscore the fragility of protections for human rights across the globe and affirm a broader point about the exceptionality of process, the abrogation of general rules, and the normalization of the exception that go hand in hand with the national security playbook. His release and his plea bargain does not change that. Second, I would say that what we see is this misuse of counterterrorism and security measures are not exceptional. They are consistent and constant. Third, when states deploy national security measures and counterterrorism measures, they consistently enter a realm of exceptionality where human rights deficits pervade and simply the normal rules do not apply, creating a host of vulnerabilities for further and layered human rights violations. For Mr. Assange, the abuse of process was in fact the point. Process functioned collectively as punishment, deterrent, and stigma from preventing him, but also signaling to others what the cost of human rights work is. Finally, let me note that counter-terrorism and national security misuse have pervasive and evident discriminatory aspects, specifically the use of national security measures against religious, ethnic, and cultural minorities, women, girls, LGBT and gender diverse persons, Indigenous communities, and historically discriminated against groups. I want to stress, even in this case, that while we talk about indirect harms, and while the ostensible target of the national security measures and charging is a man, the families of those targeted are also in the direct line of sight for the state and experience harassment, surveillance, direct economic consequence, and stigma in their lives. And here, I think it's important to recognize the costs borne by Julian Assange's wife and family as a result of the misuse of security measures and retaliation for the release of human rights relevant information by WikiLeaks. Let me also stress that it is absolutely clear that when this happens, there are few adequate remedies, and monitoring and evaluation of human rights abuses in national security context remains limited. And I pause here to acknowledge the value of this committee's oversight, the willingness of this body to pierce the veil of national security, to ask hard questions, and to push back against the presumptions that national security, once invoked, gets a free pass. It's worth saying also that as we close thinking about freedom of expression, the playbook that I have described has both old-fashioned coercive measures like detention, hence censorship, direct harm to individuals, but also that we see a new playbook of new interfaces. For example, the way in which the technologies of surveillance and interface with national security deference. And in particular here, I want to highlight the existential threat posed to freedom of expression and assembly by the use of commercial spyware. By the very nature of this intrusive and expansive surveillance, its no-click aspect, its capacity to alter without trace, what we are seeing across the globe is self-censorship by those who challenge the state and who stand up for human rights. Europe, including the Council of Europe, needs to lead the way on regulating, in particular surveillance, but most particularly commercial spyware. And here I urge this committee to take that task on board, particularly building on the Spyware Pegasus report. So let me close by saying, what do we do in response? Well, first, we name the problem and articulate the harms consistently. It's not just a bad apple problem, but a systemic association of counterterrorism with abuse of human rights and evidence costs to civil societies. Human rights have to be a non-negotiable dimension of every counterterrorism and national security regulation. We have to cease the space we have, which is a space of exemption and exceptionality, because they do not serve us well. Second, we need to provide meaningful remedies for breaches of human rights while countering terrorism. We have to make it too costly for states to shut down freedom of expression and speech. And this is not just about naming and shaming, but it's about compensating those whose capacity to investigate, whistleblow, and show us the harms have been compromised. We have to support citizen journalists, whistleblowers, and advocates. We need to give them a seat at the regulatory table. We need, fourthly, to regulate spyware. And finally, ultimately, states need to pay for human rights. As I've observed in the last 7 years as Special Rapporteur, one of the things that we have seen is the failure to pay for and stand up for human rights consistently, as counterterrorism operates like a Pac-Man, eating up everything around it. To resource human rights is to protect human rights. And I urge this committee to focus on that matter as well. Thank you all.
Thank you, Professor.
With the
and I'm delighted that we were able to hear you with such crystal clarity. I hope that you'll be able to remain with us. Could I invite Ms. Vincent to now address us? And again, if you don't mind, Ms. Vincent, in the event that your signal breaks up, I may invite you to switch off the video, but in the meantime, we would greatly prefer that you keep it on. Thank you.
Certainly, let's hope for a good connection. And just let me start, please, by saying thank you for the kind tribute to Christophe Deloy, RSF Secretary General. We, in fact, did so much work together on this case, and he would have been delighted by today's news. I'm joining you, in fact, from our Paris headquarters, sitting in the chair that he would have sat in to do such events and such interviews, so it's very poignant today. I will somewhat spontaneously adjust what I was hoping to say to you today in light of today's developments. And I've been speaking to the world's media for the past several hours, so I've not been able to send an updated version to the interpreters. I apologize for that, and I will try to speak clearly so that those following in other languages will also have the full information here. I will lay out why my organization, Reporters Without Borders, has so actively campaigned for the case of Julian Assange, what it means for us, for journalism and for press freedom, and then maybe a bit about why today's developments have been so long coming and sort of the lessons that can be drawn to ensure that this cannot happen again. We have defended Julian Assange from the very beginning because of his contributions to journalism. So at Reporters Without Borders, we believe that the publication by WikiLeaks in 2010 of the leaked diplomatic and military documents informed extensive public interest reporting around the world, including by the New York Times, The Guardian, Le Monde, El País, and Der Spiegel, which were the 5 original media partners of WikiLeaks who worked together to treat the leaked materials journalistically, but also in reporting by hundreds of other media outlets over the years. The publication of these materials exposed information in the public interest, including war crimes and human rights violations that to this day have never been prosecuted. Only the publisher is being pursued. Had the US government succeeded in its efforts to secure Julian Assange's extradition to the US and bring him to trial there, he would have been the first publisher persecuted under the Espionage Act. This outdated law has itself become the focus of growing calls for reform, in part because it lacks a public interest defense. That means that no publisher, journalist, or journalistic source accused in this way could defend their actions as serving the public interest. Although the US government had put much emphasis on other accusations against Assange, namely the allegations of solicitation of hacking, it's important to note that the bulk of this case had been based on Espionage Act charges. This was 17 of the 18 counts against him. This would have set an alarming precedent that could, as we cautioned, change the very future of journalism, as it could pave the way for similar persecutions of journalists and media organizations around the world. So one concern that we have and we will learn more information about the deal later today when it is released. We have not been able to scrutinize it yet because it's not been released yet, but that any part of this case that stood leaves that door open, in fact. And until the Espionage Act itself is reformed, this could be used against another publisher, another media organization. It has alarming implications for those who work around the world with classified information, which is a normal practice of journalism. So regardless of the terms of this deal and what happens next to Julian Assange, there remains a very urgent need for reform of the US Espionage Act. As part of our global campaign for the release of Julian Assange, Reporters Without Borders was the only NGO to monitor the full extradition proceedings in UK courts, which commenced in February 2020. I want to touch upon this because we had extreme difficulty in accessing the hearings, which is why we're the only NGO that's monitored throughout. It's become easier in recent stages at the High Court, I must say, which has respected our right as NGO observers and accommodated our requests for observation. But in the first few years of hearings in particular, especially during the first instance proceedings, there was no clear path for us to gain access. We were treated as different to the media, but no different to the public. That meant that we had to fight into court at each stage to do our jobs. The Judge Barrett, sir, in the first instance proceedings, would not allow us to access court in any way apart from fighting for very few seats in the public gallery, which became extremely difficult, especially during the pandemic. Sometimes only a few seats were made available at all to any member of the public. So accessing court often entailed having to queue for 4 or 5 hours to even get in, let alone then having to follow complex proceedings, come out, speak to the media, write things up, and otherwise do our jobs. I want to highlight that because we have at Reporters Without Borders never experienced such treatment in trying to do our jobs as NGO observers monitoring court proceedings in any other case and in any other country, even countries much further down our World Press Freedom Index like Turkey. Again, it has gotten smoother in the recent phases, so it's worth noting that the High Court seemed to be attempting to rectify some of the problems that us and other NGOs experienced in earlier phases, but at no point has it gone smoothly. It's a constant series of evolving barriers which we feel impact the right to open justice and a fair trial. We also had great difficulty in attempting to visit Julian Assange in Belmarsh prison. We are the only NGO that did gain access to do so. And again, that came with a fight. We were first vetted and had a visit scheduled in April last year, 2023. Myself and Christophe Leloy, we reported to Belmarsh prison to join Stella Assange for a scheduled visit to Julian. At that time, the prison refused to grant us access, arbitrarily barred our access, stating that they had, quote unquote, received intelligence that we were journalists and that we could therefore not be allowed in. What ensued was about a 4-month struggle to gain access. We submitted subject access requests. We engaged in lengthy correspondence with the prison governor. At one point, a UK MP intervened, and finally we came to an agreement with the prison, which was concerned about how we would use the information publicly following our visits. We had to put an agreement in writing that we were not fully comfortable with, frankly, to be able to visit Julian. And now that he's out, as far as I'm concerned, we can speak freely about our visits. But we were able to get in total 6 times, starting in August. My last visit to Julian was about a month ago on the 25th of May. During those visits, we had concerns about his mental health and his physical health, which were both at risk in prison, and both had exacerbated following this period of prolonged detention. During one of my visits in January, I noted in particular he was suffering from a respiratory illness. It possibly could have been COVID, however, no tests were available, but he had been coughing so much that he had actually broken a rib and was in a great deal of pain, in addition to coughing frequently and being unable to sleep properly. So at times we've had serious concerns about his physical health as well as his mental health. And of course, even greater concerns if he were to face conditions of extradition. Through our campaign, we engaged in extensive advocacy with all of the states involved, one of which is a Council of Europe member, the UK. We are still disappointed in the UK's role in this, effectively enabling this very dangerous prosecution. At each stage where the UK could have politically intervened in this case, it instead bowed to the US requests, including the initial request by the US government to allow this to be a matter before the court. The Home Secretary in 2019 greenlighted this request, which is why it became this now years-long process before the UK courts in the first place. This was followed by another Home Secretary last summer signing the extradition order itself, which is where we had landed in the legal proceedings that followed. So I want to emphasize this because it was a political choice that the UK made. Instead of acting in the interests of journalism and press freedom, they chose to enable this prosecution. This sends a worrying signal to others that may face similar circumstances, possibly avoiding charges in more authoritarian countries much further down our World Press Freedom Index, but it sends a signal that London cannot be considered a safe haven for those wanted on national security grounds or for other reasons linked to their journalistic work. And so that is something that longer term we would like to see addressed with the UK as well. But of course, it's always been the US government behind this case. We have long engaged in advocacy seeking a political solution because this has always been a political case. So nothing at this stage can undo the past 13 years. And Julian Assange has indeed paid a very high price for taking a stand for freedom of information and for journalism and for all of our right to know. But as we've said, it's never too late to do the right thing. So we are very encouraged and welcome the US's move at this late stage to bring this case to a close. And crucially, it must ensure that Julian Assange does not spend any further time in prison. At Reporters Without Borders, we were geared up to take this fight to Europe. I know many of you would have followed with interest too, and had there been a European court case on this, we were prepared to submit an intervention on his behalf. We had high hopes that the case would be legally treated in a different manner at the European level, because it is a clear violation of many of the founding principles enshrined in the European Convention on Human Rights. It is a welcome relief that this case will not continue to drag on and to come to that point, but mobilization at the European level remains needed, and beyond Europe at the international level. We believe that one of the reasons that the US has now come to the table with a deal is because of the growing political pressure around the world. A growing number of states have made it clear that they did not view this as compatible with our shared values. Especially advocacy over the past year or so by the Australian government, which engaged in diplomatic negotiations with the US government on behalf of its citizen. But we should all internationally remain concerned that the US did pursue somebody in this way outside of its borders, somebody who was not a US citizen, who had no ties to the US, who had not resided there. He was an Australian national living and working in London at the time of this. We should be very concerned that for 13 years, the US government was able to pursue somebody in this way. And that could be a cautionary tale for others. European countries should take note, and we would urge all Council of Europe member states to stand up for journalism and press freedom and to act in line with your European Convention obligations if such a case ever presents itself again. In the meantime, we remain concerned about many other cases of journalists targeted in connection with national security around the world. We have a forthcoming report ourselves on that as a broader topic, which should be out in a few months' time, which we'll be happy to share with the committee. But as an immediate concrete step, it would be fantastic for members of the Council of Europe to maybe express in their interventions with the US government the need for Espionage Act reform, in particular, to cease the weaponization of that law in connection with journalistic activity such as this. So I will pause for now because I know we have other valuable contributions, but I'm very happy to take questions or to engage in further discussion on this. And thank you again for convening this important hearing, which ended up being even more timely than we could have imagined.
Thank you, Ms. Vincent, for that extremely helpful and eloquent contribution. Could I turn now to Simon Crowther and ask that he address us? Thank you, Simon, and thank you for being with us here.
Thank you. Can I begin by thanking the Committee on Legal Affairs and Human Rights for the invitation to speak to you today, and also to the rapporteur for her important work in this area. I'd also like to extend my condolences and the condolences of everybody at Amnesty following the tragic passing of Christoph. So our sincere thoughts are with you, Rebecca, and everybody else at RSF. I'd also like to thank and apologise to the Council of Europe's incredible interpretation team. The speech that I'm giving was sent last night and has changed drastically since then. Obviously, a lot has changed in the last 24 hours. And we've seen momentous shifts in the Assange case. I'm going to focus on what has been reported so far, but of course this is a fastly evolving situation. Amnesty International take the view that the case of Julian Assange is important for two sets of reasons. The first regards his own treatment, and the second regards the implications of this case on freedom of expression more broadly. If I begin with Assange's own treatment, he is being prosecuted under the Espionage Act and formerly the Computer Fraud and Abuse Act for allegedly soliciting and publishing classified materials and for allegedly aiding his source in obtaining them. Now, as you will all know, last night the news broke that Julian Assange is going to plead guilty under the Espionage Act to a charge of, and I quote, conspiring to unlawfully obtain and disseminating classified information. Assuming the US court accepts this plea, it's suggested he will be released, having already spent 5 years in prison. What Julian Assange did was facilitate the publication of thousands of documents, many of which disclose alleged war crimes, crimes against humanity, and other human rights violations. This is something that journalists and publishers do the world over. They receive leaks from sources and they publish, classified material where there's a clear case of wrongdoing by a state. Yet, in Assange's case, this has resulted in an indictment for espionage, and this is extremely concerning to us. In addition, there was the question of Assange's treatment if he were extradited to the US, as there was a very real prospect that he would be held in prolonged solitary confinement. Now, the US, if they were here, would say that they provided a diplomatic assurance that this would not happen. But having read that assurance, we at Amnesty International were not convinced, as it has very significant loopholes and caveats in its text. It's worth recalling that under international standards, including the Mandela rules, prolonged solitary confinement is strictly prohibited, and we would argue constitutes torture or other ill treatment. To put this in the terms of the Convention, our position here is that there was a very real risk of an Article 3 violation. As I say, the assurances on treatment were riddled with loopholes in this case, but even if they had not been, Amnesty International are, as a matter of principle, opposed to the use of diplomatic assurances in cases where there is a real risk of Article 3 violations. Such diplomatic assurances are not legally binding, and by their nature are only sought in circumstances where a receiving state has a bad human rights record, bringing into question whether the assurances can be relied upon in the first place. So, to summarise, what we were seeing in the case of Julian Assange was a publisher being extradited for doing something that publishers the world over do legitimately and do so frequently, and facing the prospect of being held in conditions that amount to ill treatment if he were extradited. The plea deal that we saw yesterday changes things. It's now highly unlikely that Julian Assange will be held in prolonged solitary confinement. In fact, he's likely to be free within days. This is, of course, excellent news for Julian Assange and his family, and those of us who have been campaigning on this case can to some extent sigh a breath of relief. But I will now turn to the second set of concerns, which relate to the implications of his case on freedom of expression. This case cannot be seen in isolation. It is part of a much bigger picture. In the case of the US, what we see here is a very clear message being sent to publishers and journalists the world over. If you receive classified material, if you publish that material, even if there is a clear public interest, you too could be next. And it does not matter where in the world you are. Of course, to those of us who are acquainted with Article 10, this is a clear violation of the right to freedom of expression. And the European Court of Human Rights has very good case law on this matter and have labelled this the chilling effect. It's worth reiterating that the current stage of this process is an extradition request from the US to the UK to face charges in the US. So there's every chance that ultimately, if Julian Assange had been extradited to the United States, he could have been found not guilty and potentially have been acquitted if he were tried. But the point is, and it's a key point, that even if this were to have had happened, the loud message would still have been sent that future publishers could themselves still face 5 years in pretrial detention and a lengthy legal process, just as Julian Assange has to date. The same can be said for this plea deal. It is, of course, understandable why somebody who has been detained for 5 years would accept such a plea deal, particularly when they had no other prospect of release in nearby sight, as it allows for that release. But the message being sent to publishers and journalists the world over by the US is a no less positive one. And I have to say that the UK does bear some responsibility for that, for its complicity in getting to this stage. We are clearly entering a phase in history where those who expose state wrongdoing are going to have to think twice before proceeding, because they too could face national security charges. It's been reported that officials in the US Department of Justice used to refer to this as the New York Times problem. In essence, that if they were to prosecute Julian Assange for publishing the material that he published, why would they not also prosecute the New York Times? the Guardian, and any of the many other media outlets that published these leaks? And what would the implications for freedom of expression, or the First Amendment as it is in the US, be if they were to do so? And these were the reasons that initially the US held back from prosecuting Julian Assange and held it not to be in the public interest to do so. But unfortunately, that decision clearly changed. So what this results in now is a precedent, a very strong precedent, that those who publish leaked material are at risk, be they publishers or journalists, and irrespective of how weighty the public interest is in releasing that material. And that risk is not just from the US, as this case was being pursued through the courts of England and Wales, that although we're moving towards a High Court judgment, had not yet reached a High Court judgment holding there to be a clear human rights violation. There's also a geopolitical risk. If the US, or a geopolitical precedent, if the US is to seek to extradite Julian Assange, why can other states not seek to extradite any of the publishers or journalists who expose their own wrongdoing? At Amnesty International, we ourselves do this all the time. We work with whistleblowers who tell us about state wrongdoing, and we rely on that information and we publish it when it's corroborated. If this is, I should add, we also rely on journalists who similarly are able to publish based on the information that they receive. What we're seeing is a trend of national security offences being misused to target those who expose state wrongdoing. One of the questions I've been asked is what the implications of this case is on whistleblowers. To be clear, Amnesty International considers Julian Assange to be a publisher rather than a whistleblower himself, but he clearly received information from his source, a whistleblower, and he published it. If this is how publishers are to be pursued, then it will surely have implications for future whistleblowers, who will both have to consider their own actions, but also consider what support they could receive from potential publishers, who often do support whistleblowers and help them to avoid persecution. So this has really significant ramifications for those who expose wrongdoing, human rights violations, war crimes, and other significant acts by states that we all have a right to know about. Indeed, in the US, we have seen similar charges being brought against whistleblowers such as Chelsea Manning, who was, of course, ultimately pardoned, but not before receiving a 35-year sentence. I'd like to finish by looking forward and considering what comes next for freedom of expression in the context of growing national security-related repression. The Assange case will cast a very long shadow, and we need bodies like PACE to help us in addressing the harm that has been caused by it. Lessons need to be learned, recommendations need to be made to member states, and we need to prevent similar situations in the future, and to reassure those who expose wrongdoing that they will be protected. Thank you.
Thank you very much, Simon. As I say, not only for being with us, but for that insightful contribution. I'm going to open up the matter for questions from members, but before doing so, I'm going to exercise the non-existent prerogative of chairing this meeting to ask one or 2 points, first of all. Professor, I was rather taken by your reference to the term process as punishment. And I think I understand what you mean by that, but I wondered if you might be able to just very briefly elaborate upon that. And Simon, we appreciate the disclosures that went to expose state wrongdoing, some of it truly awful. But WikiLeaks also exposed material which, on one view, intruded upon others' human rights, such as the right to privacy. And does that not suggest that at some stage there has to be some balancing? I'm not suggesting that you can balance state wrongdoing, but there has to be some sort of balance that we can achieve having regard to Article 10. It's not black and white, it's actually a very complex issue. Professor, could I come back to you just on that brief point? Thank you.
Sure, thank you, Chair. And I'll just close my video to make sure that the sound remains good given previous challenges. So I think this point about process as punishment is central to the use of national security powers. And it follows a long trend that we've seen, I would say, in many national systems. First, of using long-term preventative detention as a means to avoid the scrutiny of the courts and the oversight needed to address whether a person is rightly accused and in fact substantively responsible for an offence. So we just underscore this is a broad and generic problem, not a singular one in the case of Julian Assange. But I think the point is well illustrated by the case of Assange, which is the very exceptionality of the process of his detention and the unusual way in which, in fact, courts extended his detention, including, for example, on the basis of that he would flee, or that the nature of the crime themselves merited his detention in ways that was simply not commensurate with what others again would say was protected acts under international law. So I think it's really important that we understand that, in fact, simply detaining a person and then excoriating them without access to family, without access to lawyers at significant points, with scrutiny and oversight and a term of confinement that also, per the Special Rapporteur on Torture, failed to meet the standards of international law and engaged the prohibition on torture, inhuman and degrading treatment in itself, then it's clear that the process is in fact the punishment. And that's certainly, as I think we will all regard this plea bargain closely, that I think the plea bargain itself underscores the point, not just for Mr. Assange and his family, but more broadly, the signal, as Amnesty, as Simon Crowther has said, that the process sends to other publishers, to other whistleblowers, what the costs will be should they publish, disseminate, or speak about information which the public and the international community has a right to know. Thank you.
Thank you, Professor. Simon, would you be able to come back just for a moment on my point, and then I'll open it up to members and the rapporteur.
Certainly, thank you. There are three key points really here. The first is the chronology. So our understanding is that WikiLeaks and Julian Assange were redacting the material fairly significantly. They created a backup of that material, and a media partner published the codes to release the contents of that backup, which then put the entire unredacted content into the outside world. And it was only at that stage that WikiLeaks themselves ceased to redact and did the same. So I think there's a question about culpability there for WikiLeaks. The second point is that we've not seen evidence of significant harm put forward by the US. There are certainly allegations, and it may be that had this case progressed to trial in the US, that evidence would have been forthcoming. But we are 5 years into the process now. So one would certainly think that if there was significant evidence of that, it could have been disclosed by the US. And then I think the third and most important point is about proportionality. And it's about the fact that these were charges brought under the Espionage Act with no public interest defence of any kind available. And that really, I think, was the reason why, or potentially one of the reasons why a plea deal has been offered by the US, is it was becoming increasingly clear that the High Court in the UK was not happy about the lack of a public interest defence and was recognising that would not be a human rights compliant extradition.
Thank you. Thus, the Court of Appeal allowing an appeal under reference to Article 10 of the Convention when it granted leave on the more recent grounds.
No, I'm so sorry. Could you repeat the question?
I think I was alluding to the fact that when the Court of Appeal of England and Wales recently allowed leave to appeal, when the Court of Appeal in England and Wales recently allowed leave to appeal, it did so under reference to Article 10.
Yes, that's absolutely right. And I think it was in recognition of that the US considered that they may not win that appeal and that it may be a good idea to enter a plea deal. But I can only speculate on that.
Yeah. Now, can I invite Sunna, first of all, to come in with questions, and then could members please indicate if they wish to raise a question, and if they could just turn up their cards, their name cards, we can then take them in some order. Thank you. But Sunna.
Thank you, and thank you to all of our experts for their excellent interventions. I have questions that I think all of you have something to contribute to, so I will just phrase them in a rather general manner. One of which was touched upon by most of you, which is what WikiLeaks exposed. And perhaps it isn't discussed enough exactly what it was, but I mean, the collateral murder video and the documents around it revealed on a massive scale alleged war crimes, huge death toll that was unreported to the public, alleged complicity in torture and other war crimes. And it has sort of fallen in the shadow of this prosecution of Julian Assange. So what at the beginning appeared to be a breakthrough and a huge revelation about wars waged in our name, waged by many of our member states or our allies, and the great human suffering it caused, along with many other revelations that came about the people present in secret prisons, their names, and so on and so forth. I would like you to reflect on the level of impunity for these revelations. If we compare that to the 13 years of confinement that Julian Assange has endured, and of course Chelsea Manning, which was mentioned here before, being the only people having been held responsible for, I mean, if we just look at the collateral murder video, I would say that it's quite clear if you shoot a person that is heavily wounded, crawling to safety, and the car comes to pick that person up, to bring them to safety, and you also shoot up that car containing 2 children that are also heavily wounded, and there was no consequence to that. Because we're talking about this chilling effect. And it also sends a clear message, and this is what I'd like to have you reflect on, that all of these alleged crimes are revealed, and what happens is that the messenger is shot. So the chilling effect is not only that reporting these kinds of things will get you prosecuted, it is also that there is no justice for all of these alleged crimes. There's no investigation, there's nothing that follows, and actually that is forgotten, and what we end up with is Julian Assange confined for 13 years and Chelsea Manning being eventually pardoned, yes, but after much suffering in prison. That's the first aspect of my remarks, and the second one, I wanted to focus on the transnational aspect of this case as a trend. Now, this is something that we've been covering in the Assembly as well. We call it transnational repression, and it is the increasing tendency of states to use international collaborative bodies to repress their people across borders. Now, in this case, it's not a US citizen being repressed by the US state, but an Australian citizen situated in the UK. But I think it follows very similar tracks to these trends that we are observing, which is that Interpol red notices and other mechanisms that are like extradition requests are used by states to follow their dissidents across borders, to silence them even once they don't see any other option than to flee their country because of their opposition to the powers that be. If you could put that in context with this case. Thank you.
Thank you. Could I ask our experts in turn to address those questions? Perhaps beginning with you, Professor, and then inviting Miss Vincent and then Simon to come in. Thank you.
Super. And again, I'll just stay off video in case we continue to have poor reception from Belfast this afternoon. So I think it's really important, and the rapporteur soon is sort of bringing our attention to what was exposed is critical. And the amnesia, I think, that we have about the degree of information and the importance of the information that emerged from two highly contentious conflicts in Iraq and Afghanistan, conflicts that were defined by systemic human rights and humanitarian law violations, not only, of course, by non-state actors, but critically by states who had international obligations under treaty and customary international law. And the extent to which, in fact, there has been zero accountability. And in fact, at least, and in particular in the case of Iraq, what we saw in recent decade was effectively impunity through the use of pardon power for even those very few individuals who were convicted of serious violations of international law committed during that conflict against civilians protected under the Fourth Geneva Conventions. So it is really critical that we understand where actually the notion, where the interest, where the public interest lies, but also the obligation of prevention and accountability that states have. And that obligation is clearly what we're seeing in reverse here, which is not state attention to their obligations, whether it's under international humanitarian law or human rights law, or even international criminal law, but rather their focus is punishment and obstruction of the person or individuals responsible for bringing that information to the public. The other WikiLeaks document documents that I would also stress is the information that was made available about Guantanamo, the abuses that took place at Guantanamo Bay, Cuba. As the only international human rights expert who has had access to that facility, negotiated by my mandate last year and concluded with the US government, the report I issued stressed the extent to which ongoing impunity for the torture and rendition of over 700 Muslim men and boys, the absolute what might be described, Lord Stein of the United Kingdom described it as the legal black hole of Guantanamo, underscores the extent to which, again, systematic torture and crimes that rise to the level of crimes against humanity, as defined by special procedure mandate holders, were committed with impunity at Guantanamo. And again, what we have seen is impunity. So the point is underscored about the extent to which the obligations of states and where the logic of that obligation sits is in direct contravention to what we've seen happen. And I would just, on the second question on transnational repression, I would just underscore the extent to which this remains one of the most challenging practices of our time. Key to this, of course, has been continued insistence, including in Security Council Chapter 7 resolutions, of cooperation between member states. But actually, this generally constitutes human rights-free cooperation. We've seen systemic abuses of red notices, many of which have been documented by the mandate I previously held. And I would affirm the point about assurances. Diplomatic assurances are generally, as we've seen again, in relationship to the men who've been transferred out of Guantanamo Bay, Cuba, to third states, are not worth the paper that they are written upon. And in this regard, we see diplomatic assurances, I think, as one of the sort of flashing red areas of state practice, which demonstrates, in fact, a cart and horse being pulled through the protection for the jus cogens norm of torture. So let me stop there.
Thank you, Professor. Ms. Vincent, would you like to address the points raised by the rapporteur? Thank you.
Certainly, I think it's hugely important, as the rapporteur has mentioned, to focus on what was actually exposed. For those of us working in press freedom, of course, collateral murder was completely shocking, that we have documentation of 2 journalists among a broader group of civilians gunned down with complete impunity. And to this day, it has only been left to the US to conclude that there was no violation of its own rules, which also the rules were leaked by WikiLeaks, and that's the only reason we know about them. There needs to be justice for those killings and for many other acts exposed through these documents. We've worked on this mostly in terms of how these documents were then effectively used as source materials for the media. There is still public interest reporting taking place to this day on the basis of the leaked information. But that being said, I think the rapporteur's comments about the lack of activity to address any of these violations can contribute as well to a chilling effect with media. Very few people would be willing to go through what Julian Assange has gone through for 13 years for any story. But if that's combined with this lack of action to ensure any sort of meaningful accountability, that in and of itself also contributes to a chilling effect. I think with those 2 factors, we will already not know what stories have never been published in these intervening years as a result of this. So I think both factors have to be looked at very carefully. And one reason that we need to ensure accountability when such information is exposed is to make it clear that that channel is open, that there can be whistleblowing, that there can be courageous journalism on such acts, and that it will ultimately matter. I wanted to touch upon a related issue as well, which is in all of our years of campaigning for Julian Assange, one thing that has really struck me is I've never before worked on a case where so many people believed things that simply were not true about the case, or that were taken grossly out of context or twisted. I think in examining this and drawing lessons and ensuring that this chilling effect doesn't take deep hold, that needs to be assessed carefully, both in terms of the role of the US government and other governments and the story that they told about what had happened, but also, frankly, some very unhelpful reporting by media itself, which was not always based in truth. And so some of that was intentional, possibly misinformation, and some of it was misunderstandings. And so that made it very difficult for us as campaigners to work effectively on this case. And again, could serve as a deterrent for anybody wanting to put their neck out on such issues in the future. As a campaigner, I'm almost always trying to inform and mobilize the public on cases that they may not be aware of or may not know much about. But with Julian Assange, we found everybody had a deep-seated view of the case that may or may not be rooted in fact, and it was very challenging to counter. In fact, even to this day, with the reactions that we're getting to today's developments, we see this proliferation of misinformation continue. The transnational repression angle of this is very concerning as well. We have often cautioned what that means for global media. And again, that remains a risk, even with this deal, or perhaps particularly in how this has been done. It would have been stronger for this case to be closed in its entirety, for all the charges to be dropped. The fact that there has been some criminal responsibility left here, it can present the opportunity for this to be used against others. And we've tried to always flag that it wasn't just a question for US media, but that others around the world have to worry that a government as powerful as the US can go after them in this way. And again, the role of other states is crucial in that we shouldn't see protracted extradition situations as we did in the UK. We would very much hope that members of the Council of Europe would take a stand in the first instance. The danger in allowing cases like this to go forward, especially for as long as this one did, is that in our democracies and in bodies like the Council of Europe, our states are expected to take each other in good faith. And perhaps that's why this has dragged on as long as it has. In truth, our systems in the US and the UK, on the continent in Europe, are not meant to have cases of political prisoners, but we know that that happens. And this is an example of how it's happened, not just in, again, countries down further on our World Press Freedom Index, but even in our democracy. So it is of the utmost importance to learn lessons from this, to hold our own democracies to account, for states to behave according to their own stated values.
Thank you. Simon, could I invite you to come in? There are a few moments left, so please, before I invite the rapporteur to respond, could you just address the points that have been raised as well?
Sure, thank you very much. When I'm trying to be optimistic and to cling to a grain of hope on these revelations and the impact that they've had, I would focus on the significant media coverage that they had gained at the time, the fact that they were put before the European Court of Human Rights in cases like Al-Masri and the International Criminal Court. But when I let go of that attempt to be extremely optimistic and to cling on to a grain of hope, I revert back to the fact that there's been a shocking accountability deficit for the alleged war crimes that were shown in those revelations, for all that's happened in Guantanamo, for all that happened in the war on terror. And while it's fantastic that the European Court did rule in claimants' favour on the back of these revelations, and they clearly had a significant human rights impact, I really do think it would have been history will look back at the lack of accountability through a very negative lens. On the question of transnational repression, this is something that Amnesty International are working on extensively. We've seen misuse of red notices, we've documented renditions for decades, and those are ongoing. And more recently, we've been seeing students being shadowed by their country of nationality when they are studying abroad. And finally, on the point of assurances, I strongly agree with all of that has just been said. Amnesty International take a very dim view of diplomatic assurances on ill treatment and see them as fundamentally undermining the prohibition on torture, because they are so frequently violated and they are used as a fig leaf of legitimacy to something that is quite dangerous. Thank you.
Thank you, Simon. Sunna, could I ask you just to take a few moments to sum up, and thank you.
Thank you to all the speakers. I think brave whistleblowers such as Chelsea Manning and Edward Snowden have showed us that democratic governments shouldn't be trusted to work in the dark, because what we see is mass surveillance, massive human rights violations, massive war crimes, and they try to hide what they are doing behind the veil of secrecy. And when we allow them to go after the people that tell us about these violations and we do nothing about it, we are strengthening this state of affairs. We are enhancing a secretive, proposed security infrastructure that doesn't serve for our security, because with our rights we don't have any security. And therefore I think this case is as important as ever. The fact that Julian Assange has had to accept to plead guilty on espionage charges for having told us and for having shown us the collateral murder video, for having published the information that comes from one of these brave whistleblowers. It tells us a chilling story about the state of our democracy. And as hopeful as I was, at least personally, when these revelations first came to light in 2010, I thought now something really must change. The development, I think, has been in the completely opposite direction. We have allowed ourselves to succumb to fear, to depend way too heavily on secret services and secrecy and anti-terrorism units and surveillance. And I think if we look back on this chapter in our history, we will realize that this was not to make us safer. This was to weaken the foundations of our democracy and the foundations of our society. And I hope that we can move towards a safer path for us all, where the rights of everyone are respected, where people who are accused of grave human rights violations or war crimes are held accountable, and where we can again start building the foundations of true freedom of expression in Europe and the world as a whole. I know that we will not do that with this report, but I think it is important that you have contributed to it. It is important that we hear your opinions on this matter and that we continue to follow the case of Julian Assange, hopefully as a free man. And I hope that we'll be able to speak with him in person, if not by video link, very soon as a free man. So I thank you all for coming and for your participation in this event. Thank you.
Thank you, Sunna. Could I express my thanks to each of our experts for their contributions today? And what they've made clear is that one small story with regard to Julian Assange may be drawing to a close, but that's hardly even a chapter, let alone the entire volume that's going to have to be addressed as we take this forward. So I thank you again for your contributions. Colleagues, that brings this meeting to an end, and I just mentioned that formally we will meet tomorrow afternoon at 2 p.m. in room 7. But before I go, could I also extend my thanks to the interpreters for dealing with what was a rapidly changing situation and one which they accommodated. Thank you all.